right. So I guess first matter up is page 1. So is that page 1? Yes. Yeah. Page 1, estate of Wilfred Richard James Bosserman versus William Errico. Let's go ahead and set forth our appearances for the record.
Michael Van and Garrett Chase on behalf of the estate of Wilfred Bosserman.
Good morning, Your Honor. Matt Johnson on behalf of the defendants.
Okay, gentlemen, and once again, good morning. I do see we do have this matter on the stack, and just as important too, I do see we have, I guess, set this afternoon, we have motions, right, that we have to deal with. And then we have the jury trial. What do you want to do, gentlemen?
Your Honor, this is Michael Van on behalf of the estate of Wilfred Bosserman. I spoke with Mr. Johnson this morning. I wouldn't care if you pass the trial, the calendar call till this afternoon, with the understanding that I believe that we're going forward and we're prepared to go forward. And then we can just deal with it all this afternoon, not waste your time this morning.
All right. Mr. Johnson?
That would be fine. Although, Your Honor, I'm wondering if we'd be able to start at like 2 instead of 2:30. And the reason being is I've got a flight that I think it leaves at 4:20.
We can do that, can't we?
Yeah, it leaves at 4:25.
All right. And so, Mr. Johnson, if you want to start at 2 o'clock, I mean, I don't know if this is convenient for you, but is 1:30 better? We have that.
30 works for me. Mr. Chase, does that work for you?
Yeah, that works for me, Your Honor.
Okay.
Your Honor, Michael Van. The court, I've used this excuse before. And anyway, every first Thursday of the month, I'm out in Malapa, and they told me that this was canceled this week, and so I set this with that understanding. And I got a phone call yesterday that there's 2 trials out there, so I don't want to move this, but Mr. Chase will be arguing those motions instead of me.
And that's fine. I understand. So 1:30, as far as this afternoon is concerned, and we can deal with all the issues then.
That is
right. All right.
Thank
so
you,
I'll see you this afternoon.
Thank you.
And
Thank
that
you,
way
Your Honor.
we can get out a little earlier. Maybe we'll be done by 4 o'clock.
That would be great.
And Mr. Johnson, that should hopefully give you enough time.
Thank
Maybe
you,
earlier than that. Okay.
Anything I can do to make Mr. Johnson miss his flight would be wonderful.
He's tried many times, Your Honor, believe me.
Your Honor.
Okay, gentlemen, enjoy your day.
You too.
Okay.
Thanks.
See you later.
All right, I just want to say good morning to everyone, and I guess next up for this afternoon's special session will be the estate of Wilfred Richard James Bosserman versus William Errico. Let's go ahead and set forth our appearances on the record.
Yes, good afternoon, Your Honor. This is Garrett Chase, bar number 14498, on behalf of the plaintiff.
And good afternoon, Your Honor. Matthew Johnson, bar number 6004, on behalf of the defendants.
Okay, and once again, good afternoon, gentlemen. I see we have a couple matters on calendar, and I think it's probably best, this is go in case order. I think first up would be the motion to reconsider regarding 41E.
Yes, Your Honor. This is Matt Johnson. That is our motion, and I guess we could actually call that a motion to dismiss.
Yes, sir.
Your Honor has heard arguments on this before, so I'll be brief. But essentially, this case was filed November 22nd, 2013. The 5-year rule would have expired on November 22nd, 2018. However, we had 3 different stipulations to extend the 5-year rule. The latest stipulation was November 18th, 2019. And what that stipulation said, so let me see if I can find it actually. It says, the parties reiterate their agreement to waive the 5-year rule pursuant to NRCP 41E and agree that the trial in this matter shall occur no later than December 15th, 2020, unless another stipulation is entered into between the parties, further extending the 5-year rule. Of course, that did not happen. There was no other stipulation, so the latest stipulation on file regarding the 5-year rule extends the deadline to December 15th, 2020. March of 2020 came along, and we had some issues with the pandemic. But even so, under the rules that we have cited to you previously, in fact, I think December 8th, 2020, you told us in a hearing that we needed to sign another 5-year rule extension. It did not happen. There's been a couple of administrative orders entered. March 13th, 2020, Administrative Order 20-01 stayed the 5-year rule, referred to NRS 178.556 and NRS 174, both of which are criminal statutes that do not apply. Those are right to speedy trial type statutes. The period of exclusion under that administrative rule was up through April 17th, 2020. We entered into our stipulations much before the December 15th, 2020 deadline. The second administrative order was the AO 21-04, and that superseded all prior administrative orders and is after the amendment of Rule 41C. AO 2104 clearly states at page 17 that we require good cause and excusable neglect, and it continues to stay civil trials for tolling purposes until July 1st, 2021. We've argued before, and I think your Honor has agreed, but indicated the last time we heard this, and not a continued hearing, but the next time we actually heard this, was that you didn't have to decide the issue that day. You're going to move it out 2 weeks, and then those have been continued. We are requesting that the case be dismissed. We are requesting that it be dismissed with prejudice. We understand your Honor has indicated it's unlikely that it would dismiss with prejudice. The rule does give the court discretion to dismiss with or without prejudice. Our concerns would be, number one, Mr. Bosserman, although he is, from what I understand, disabled, he does have and has had since at least prior to the 2013 filing of this case 9 years ago, approximately, he did have a guardian in place to make sure that his rights were represented, make sure that his rights were protected. And so I believe that this court has guaranteed his due process rights have been protected since at least 11/22/2013. He had a guardian. He's had a Nevada law firm watching out, protecting him. They've been protected. Certainly tolling should not occur while we're litigating. And then lastly, we would request, Your Honor, not only would we request dismissal with prejudice. I understand what Your Honor has told us in the past, that you may not do that. We are requesting it. And then we also are requesting, there was an order that was entered early on in this case through the Discovery Commissioner that was to seal and return sensitive state bar and Nevada State bank records, and we would request that as part of the order that those documents would be sealed. Obviously, we have some concerns that we don't want to spill over into the criminal case that is still pending. Unless Your Honor has further questions, I think that's what we have to say today.
Okay, thank you, sir. And we'll hear from the opposition.
Yes, thank you, Your Honor. This is Garrett Chase on behalf of the plaintiff. I'll also be brief because I know that we've argued this a couple times in front of you, and we've had to continue this out. And so I also just want to express my gratitude, Mr. Van's gratitude, for the flexibility on getting this hearing scheduled. Just to respond briefly to what Mr. Johnson said, and this is set forth pretty concisely in our supplemental brief, which was filed on the 11th of March. But essentially, we would argue that the December 15th, 2020 date was continued and was stayed by virtue of the numerous administrative orders that were entered. Based on the tolling within those orders, we calculate 527 days as the full stay period, and then based on the amendment of that rule, of Rule 41 by the Supreme Court, we believe that would apply to the December 15th date, which would push the 5-year rule to May 26, 2022. Based on that, we would argue that dismissal is not appropriate. However, in the event that the court is inclined to dismiss this case, we request that dismissal be done without prejudice. We would just note again that Mr. Bosserman is not competent to make these types of decisions, and reference statutorily there's an issue there in terms of potential statutes of limitations. But our request again would be, if the court is inclined to grant Mr. Johnson's motions and dismiss this pursuant to Rule 41, that dismissal be without prejudice. And unless the court has any other questions, I would just submit it on the briefing.
Thank you, sir. And we'll hear it from the reply with Mr. Johnson.
Yes, Your Honor. I think we have already put forth to the court our argument against that. And again, I think the court is pretty familiar with those issues. The only thing I would add in addition to that is that the administrative order is quite clear that the tolling will extend until July 1st, 2021. I can quote this order. This is at line 8, page 16 of AO 21. This order shall continue to stay trial in civil cases for purposes of tolling NRCP 41E until July 1st, 2021, except where a district court judge makes findings to lift the stay in a specific case to allow the case to be tried. So it actually allows you to move forward. I believe that the rule is the rule, the law is the law, and unfortunately, or fortunately, depending on what side you're on, the 5-year rule has expired. There was no agreement or stipulation to extend past the 20th of December, even utilizing the administrative orders, the administrative rules. We understand that December 15th was the original date. It was extended by Administrative Order 21-04 to July 1st, 2021. And we are past that. We're now in April of 2022. And so the case should be dismissed under the 5-year rule. And we would again request that it be with prejudice, and understand what Your Honor has noted in the past. And again, would reiterate, if we could have language in that order that indicates that the documents should be sealed and returned. Thank you, Your Honor.
All right. And gentlemen, I don't mind telling you this. I've really thought about this issue. And I just want to make sure whatever decision I make for the record is tempered based upon the procedural history of this case and prior decisions I've made. And you are 100% correct, gentlemen. This matter has been fully briefed, and it's been discussed, and so on. But I think when it comes down to the ultimate determination as far as the time period is concerned, I have to rest on that last administrative order. And it would appear to me, unless the time period was extended, that July 2021 has impact. The date is set forth therein. Just as important, too, and I think I've discussed this issue at the very outset of this case, and it's been a long time, I will admit. But I'm very much aware of the current impairment of Mr. Bosserman. And the reason why I say that is this is my understanding that he has a mental disability. And all that has to factor into my ultimate decision-making, specifically if I'm going to grant the motion to dismiss. And I do understand this in a general sense. I don't have much discretion when it comes to a 5-year rule. I just don't. And so I've weighed and balanced all the factors that I have to consider. And so, Mr. Johnson, what I'm going to do is this. I'm going to really do 3 things as far as the and just as important too. This essentially impacts my decision making too, as it pertains to with prejudice or without prejudice. And another factor, up until recently, I guess within the last, this case has been going on for a long time, but the last year or so, it appeared to me that everyone was on the same page, and there was a hiccup as far as making sure that whatever extension we had of the 5-year rule had a date certain. Because I think at the very first time we did that, I was a stickler, and I tried to remind everyone we have to have a date certain, and that was my concern. And throughout the whole history of this case, and this can't be overlooked either. This is another factor I'm going to consider. And this, I want this in the order, is that the parties agreed to stay the prosecution of this case because in a general sense, they wanted to have a final adjudication of the criminal matter first, right? And that still hasn't happened. That's my understanding, which I find surprising in light of the Sixth Amendment issues in a criminal case, right? But that factors significantly the delay because, I mean, we have to be concerned about Mr. Errico's constitutional rights, et cetera, et cetera. That was part of why, part of the agreement to stay the prosecution, because to be candid with everyone, I could have forced the case to trial a long time ago. But from a judicial policy perspective, what I try to do is this: if the parties are getting along and they're trying to work towards some common goal, I stay out of the fray and I go ahead as long as the stipulation and continuance meets the technical requirements of Rule 41E. And that's what I did in this case. But now we have an issue because the technical requirements aren't met, right? And so under those circumstances, I have to make a decision, and I'm compelled to do what the rule mandates, of course. I'm not going to say no. I'm not going to say I'm not going to follow the rule. However, I'm given discretion. So what I'm going to do is this. I'm going to, as far as the motion to dismiss pursuant to the 5-year rule, I'm going to grant the motion. It's going to be without prejudice. The reason for it is twofold. Number one, the procedural posture of this case and the attempt to defer to Mr. Errico's constitutional rights because he has a criminal case. Discovery was delayed because of that. I don't know why that case hasn't gone to trial yet. Probably COVID had some sort of an impact, but that's taken a long time. Coupled with that, I'm going to also consider the disability of Wilfred Richard James Bosserman. And I remember Mr. Johnson, we had a discussion at the very outset of this case. And it was a question regarding the potential tolling of the statute of limitations. And I had made a decision at that time that he suffered a mental disability based upon his mental status. And I think you probably remember that. It's probably in the record going way, way back, but that's the decision I make. And I think when you couple the parties' agreement to work to a common goal to give deference to Mr. Errico's constitutional rights as it relates to the Fifth and Sixth Amendment, well, and primarily the Fifth Amendment in this case, coupled with the mental disability of the plaintiff, that's why the motion granting dismissal will be without prejudice, sir. I just want to tell you that.
Thank you. I appreciate that. Thank you.
All right. So anyway, sir, I think what I'm going to do is have you prepare findings of facts, conclusions of law. Remember those 2 points I stressed as it pertains to placing this case in a, for all practical purposes, a stay pattern throughout the course of the litigation, because I was concerned about the defendant's constitutional rights, more specifically pursuant to the Fifth Amendment and the pending trial, and because we didn't want to have that impacted, but just as important too, my decisions based upon the mental disabilities of Mr. Bosserman. And last but not least, as far as your request to seal, I'll grant that as long as we meet the requirements under the Supreme Court rule when it relates to sealing documents. Because remember, under those circumstances, you have to prepare an order that has specific findings as to why these documents should be sealed under the rule.
Okay.
And as long as you do that, I'm fine with it, sir.
Okay. We'll do that,
All right?
Your Honor.
Okay,
you,
so
Your
we're done, right? We're done completely at this point.
Yep, I believe that moots the other motions. Yep.
Yes,
Okay.
sir.
Thank you, Your Honor.
Gentlemen, enjoy your day.
Thank you,
Have a
Your Honor.
great
You too.
day. Hey, you're moving this up too. Thank you very much. All right.
Everyone, enjoy your day.
You too. Thank you.
Thanks.